or about May 14th when you testified?
The kidnapping.
Okay, a kidnapping. So, how were you involved in the case?
I was the victim. I was kidnapped.
Okay. And is that case still going on?
Yes.
Okay. And is the case now in circuit court?
Yes.
Okay. And if you could just make sure that when I'm asking questions, you just keep eye contact with me, and we're gonna get through all the questions. So we're gonna try and go as efficiently as possible. So on May 26, 2024, what brings you into court today for deciding?
What brings me into court today?
Yes.
The person that kidnapped me, Latasha Pace. This is her father that came to pour gasoline on my car and set it on fire. So attempted to murder me, witness tampering, whatever.
Okay. So where were you on May 26, 2024?
Outside my car.
Okay, you were outside.
In my car.
In your car, outside of where?
My parents' house.
Okay.
On Grayson.
Okay. And when you say you recognize or you saw someone standing over your car pouring gasoline, what do you mean by that?
I was asleep.
You didn't say that. I think you might have read that. You didn't ask her about whether or not she saw anyone standing over her car pouring gasoline. She said where she was in the car part of the house with her other stuff.
And that's correct. That word stated in your question. She would testify on that. She stated attempted murder or witness intimidation, trying to burn up her car.
I apologize. I thought the witness stated that the individual was pouring gas on.
She didn't say anything about standing over the car pouring gas.
Okay. When
his actions was to
that way. There's no question.
Okay.
So you were outside in your car?
Yes, ma'am.
What were you doing in your car?
I was asleep.
Okay. And what happened when you were out in your car?
I woke up to two people pouring gasoline over my car. One of them was him, D'Angelo Irving.
Okay. And what do you mean by you saw Mr. Early pouring gas in your car?
I literally had just woke up out of my sleep. I didn't even hear them. I jumped up. I seen one person at my window, like right here, and it was him.
You saying right here for the record, that's to your left?
So I'm sorry, that was to my left, right by my window. I didn't have no tent. I turned around and seen another person. I wasn't able to identify that person. I still can't. I don't know who it was, but they had a bottle, every fresh bottle of gasoline as well, and they were pouring.
All right. And so, did you make any other observations besides what you saw that day?
What do you mean by that?
Did you smell anything?
Yes, I smelled a lot of gasoline.
Okay. And
I woke up to the smell of gasoline.
okay. And was your car started when you
No, ma'am. It was off.
Okay. And you mentioned Mr. Early. Is the individual that you saw outside of your car that you said you were able to identify, is that person in the courtroom today?
Yes, he's right here.
And can you describe a little bit more where he is located in the courtroom and what he's wearing?
To the left of me, he has on a green Wayne County jail outfit.
Okay. Your Honor, please let the record reflect the identification of the defendant. And do you know the defendant?
Yes.
And how do you know him?
From being with Latasha Pace, and then the day I was kidnapped, he was over there as well.
Okay. And so after you woke up in your car and you smell the gasoline, what do you do next?
My key was already in the ignition, so I heard that it turned it and I sped off. My parents' house is on the corner of Gray and Warren, so I sped off. I took a left. There is an old piece of hut that sits directly next to my parents' house, so the parking lot is right there. When I went to the left,
I'm gonna object. This is a narrative.
I can redirect the witness here. So, you stated when you woke up and you drove off, what did you do when you drove off?
I made a left.
Okay, and, did you make any observations at that point?
Yes, I looked around to see what was going on because I was obviously scared and in a panic, and I seen them in my rear view running through the parking lot close to my parents' house.
Okay, and by them, who do you mean?
I seen D'Angelo Gurley and the other person, but I'm not sure who that other person was.
Okay, and how far away were you when you saw them running?
About 20 feet, if that, I'm not sure, it wasn't far at all.
Okay, and so, after you make that observation, what do you do next?
I turned my car around because I went left at first. I turned my car towards where they were going to see if I can identify them. It is the street, the main street is more, so there's a street, an island, and then the parking lot. I rode up and I don't have any tent, so I see Thursday, the street lights were out. I see D'Angelo early and I see the other person, but the other person still had his mask on. When I seen him, I made eye contact with Mr. Early and then they shot gunfire at me.
Okay, so, where do you see them when you turn back around your vehicle?
When did I see them where?
Where do you see Mr. Early when you turn back around?
They're in the parking lot, like running to the parking lot of the pizza Hut, the old pizza.
Okay, and, how far away when you see them in the parking lot?
They were more so on the sidewalk of the parking lot and then it's an island in the street, so I can say about 20 to 30 feet. It
Okay.
wasn't that far though.
Okay, and you mentioned that you heard gunshots. Did you
Yes.
see anything?
I didn't see them myself. I seen the other defendant, the other person with the gun. I didn't see I just seen them shooting at the gun, like
Okay,
for me to get away.
were you struck at all? by
No,
the gun?
ma'am.
Was your vehicle struck at all by the
No,
gun?
ma'am.
Okay. And what kind of vehicle do you drive?
2014 Malibu, 2015 Malibu,
Okay,
2014 Malibu,
and what
I'm sorry.
color is it?
silver.
Okay, and, was there any damage done to your vehicle?
Besides the gasoline, no.
Okay. Have you ever, was your vehicle appraised?
Yes,
Okay, do you know how much the vehicle appraises for?
between $5,000 to $7,000.
I'm gonna object to notice regarding the value of this vehicle. This is not charges that we levy against my client for the effects of the damage and the restitution to this vehicle.
Judge, with regard to count two, the arson, preparation of burn, the charge does include an amount of the property that was prepped to burn. So this charge has $1,000 or more, but less than $20,000.
I'll withdraw the objection.
Okay. Withdraw. What was the value you said?
Between $5,000 to $7,000. Between $5,000 to $7,000.
Sorry.
So between,
5 to 7 thousand.
okay, between $5,000 to $7,000. Okay, and, after, strike that. What were you feeling in the moment when you were in your vehicle?
In fear for my life, I was very scared.
Okay, and, why do you think the defendant did this to you?
So I will come back and testify against his daughter.
Okay. Did you contact the police at all in regard to this incident?
Yes, I called him directly after.
Okay, and did they make the scene?
I'm sorry. Yes,
Okay. And, what did you tell
what I just told you, that somebody tried to kill me in my car, set me on fire.
them? Okay. No further questions for this witness?
All right,
Yeah. no problem.
so, Ms. Mancy, I wanted to just get some background information from you. You have outstanding warrants in Ohio County.
Yes, what does that have to do with this?
I don't answer questions at all. And you were also involved in a scheme to defraud FEMA out of money that involved Ms. Natasha Pace, were you not?
No, I was not.
You were not involved. So there is no information out there at all about you making applications to FEMA to defraud them out of money.
I didn't try to defraud them out of money.
What were you trying to do?
What is FEMA for?
Objection, Your Honor. The witness did say that she was not involved in that. She denied it.
And then she just didn't.
I didn't admit to being
She said,
in fraud.
what is FEMA for?
What's your objection?
Objection as to prior, using a prior fraud offense, but
Is there an offense that's been established?
I don't believe so.
Okay, Ms. Bella?
The witness did say that she denied the allegation.
And then she followed up with a question, with an answer. Well, she answered my question with a question when I asked her, did she have any involvement with FEMA? And she said, well, what is FEMA for? So the first answer was probably not true.
Well,
You asked me, was I understanding?
We're in the middle of a legal.
I'm sorry.
You may not have to answer any of these questions.
Okay, I'm sorry.
Ms. Bella, what is your objection?
Objection is improper questioning of the witness.
And I would, in case of the court, that it goes to credibility straight away.
Most of the credibility, Ms. Bella, but the issue here that you should be identifying is whether or not she has a conviction.
Right. And it hasn't been, our view and object as to whether a conviction has been established at all. It's an improper question and there's no basis for the conviction.
I kind of get what she's trying to say. And so I would still lean into this because it goes to credibility, which is the primary, one of the primary issues we have with the examination is the credibility of the state's witness. And with respect to any involvement or potential involvement in a scheme to defraud anyone, then that would go to her veracity. That would go to her propensity for truthfulness or lack of. So even there would be an objection.
I think we start with whether or not she was convicted.
Of course, right. But I feel like the inquiry in and of itself could have led to that if the objection had been timed differently. We don't really have any convictions, we have outstanding warrants at this point because she's fled the jurisdiction for which the cases are pending.
Judge, we would just move to strike that based on the fact that there is no conviction established and the witness in fact denied having any knowledge as to one of the questions regarding an allegation against this witness.
Conviction, I'm not going to get into the facts, those are
That's fair.
allegations.
That's fair, Your Honor. I would just indicate to the court that when you abscond, the conviction cannot be achieved.
That's true.
So, I mean, I would just leave it at that.
I know
Okay.
that all day long, experience that.
That's right. So, okay, so my next question, I want to talk about this $5,000 to $7,000 damages that you claimed for 2014 Chevy Bell. Where'd you get that number?
Objection as to relevance,
How would it not be right?
as to where she received the Malibu. I don't.
I'm not asking where she got the
The
car.
value,
Oh, I apologize. I thought she asked where she received the vehicle. I
you can answer the question, as far as where you receive the value.
I received it from the police.
So the police appraised the damage to the car.
Yes,
Do you know which police officer they gave you the appraisal?
I don't.
Okay, was it a male police officer? Female police officer?
The mail.
Male police officer? Did you put that appraisal for the damages in writing?
I'm not sure.
Is your name on the vehicle?
Yes,
So you probably have to give it to you, yes?
And just because this is the value of a vehicle, not of the damage, correct?
No, I'm
yes, the
talking about
vehicle,
the,
not the damages.
I don't care about that.
You
It
said the
said
damages.
straightforward. The value, would you come up with the number 5,000 to 7,000 damages to this vehicle?
But people believe that the question that we originally asked them on direct was
Value of the
the
car.
value of the actual.
The car is not a total loss, so therefore we only gave the number 5,000 to 7,000 in damages. And I'm asking her, where did she get that number? Because that number obviously affects my client.
The question was value.
Okay, and so now I'm asking her about the damages that are assigned to count 2.
And then people would object to relevance because damage to the vehicle is not.
So I will allow for her to ask the questions to the value of the damages, but that hasn't been answered yet, to be clear. 5,000 to 7,000 was the value of the vehicle, that she answered. So
I'm unaware of the, damages.
Okay, and so the police officer never gave you a value of the damages. So that was not true. The male police officer.
I never got anything regarding to damages. I got
Okay,
that
so
from
how about
my
this?
agent.
Why do you sleep in front of your parents' house in your car?
I don't sleep. It was one night.
Okay. And it's not because they don't trust you inside.
Objection is to
I don't have anything to do with that.
Okay. And
We would move to strike that from
as
there.
far as why she sleeps in the car,
Yeah, why she sleeps in her car and why her parents, any reason why she would be sleeping.
odd, and I'll allow for it. I don't know where it's gonna go. You may have to object again, but I'll allow for it.
And I think her answer was, it's not all the time, it's one night. Is that what you said?
It was one night.
It's one night. Okay, and you know, how you woke up, you just woke up to see my client and another person by your car pouring gas. Were both of them pouring gas?
Yes,
They both were?
yes,
And did you indicated ever fresh? So that's a glass bottle, yes?
it is.
And that was found after the police had already left, wasn't it?
No, it was found while they were there.
Okay, and that was found that night?
Yes,
Okay, by
my mom,
your mom found it that night,
yes.
so she didn't call the police later and tell them what she found?
She didn't have to, as I just told you, the police were there.
Okay, and that was on the same night?
Yes,
Okay, sure.
I'm positive.
Okay. So you said that you woke up, the car was the car on or off when you
It was
woke up?
off. My key was in
And you turned, you
the
got
ignition.
that part, so you turned the ignition and you sped off,
Yes,
you put
ma'am.
it in gear. Where were they when you sped off?
They were behind me, I assume.
Okay, so they went from being at your windows to you speeding off,
Mhm.
so they had to move out of your way, right?
Well, the one was already in the back of me, so he didn't have to get out my way. Only when he seen me turn around, when I turned the ignition, he literally shot across my car onto the sidewalk.
Was he got in front of your car?
Yes,
Oh,
That being the,
yes, ma'am.
so when he saw you start the car, he ran in front of the car,
Yes,
not away from the car?
no,
First stated that you made a left turn, is that in a corner from the house?
yes,
What
my
corner
corner
was it? What street?
of Warren and Graydon, where the first
So
house
you were
was.
on Grady and you turned left on Warren Street, is that what you said?
Yes, ma'am.
And then at some point, you did a U-turn, turning right, going toward these two people,
Mhm.
and,
you have to say yes or no.
Yes, ma'am.
and when you were going toward these two people, were you going at an accelerated rate of speed, or you just kind
I didn't have to be, it was right there. I was just riding.
of, okay, you said it's right there, what does that mean?
Like when I made the lift and I seen them in my rear view and I seen them going across, I turned around and I cruised up to see if I can see who it was, and I did.
So you indicated that you recognized this gentleman from another time,
Yes,
okay, and when was that other time that you saw this gentleman?
I seen him twice before that, when he came to my grandmother's house in the car with his daughter when Latasha's face was up. And then when they kidnapped me, he was at the house.
He was at the house.
And they
where-
kidnapped
where-
me, when they held me.
Okay, so you're saying he was at the house where they took you?
where they had held me at.
Okay, and, communicated you were traumatized and upset, yes, on the night of this incident?
I was.
And are you absolutely certain you're seeing him because you saw him or because you had a prior interaction with him that was also traumatic?
No, I wouldn't put anything on nobody that they didn't do it. I didn't even recognize the second person. I seen him with my own 2 eyes.
Okay, and you said that they were wearing masks, right?
The other guy was, his mask was dropped for whatever reason.
His mask
He
was
had
dropped.
dropped early.
Okay,
I'm not even sure if he had one. I know I see his face.
okay, but you had seen him before too?
Yes, I
During
have.
a traumatic event? Yes?
Yes, and during a non-traumatic event.
Okay. So when the police got there, you spoke to them about the previous case with this case, yes?
Briefly,
Okay, but you made an effort to make sure that you could explain to them the relationship between what happened in that case, yes?
briefly.
What does that briefly mean? Did you do it?
Briefly, that's what I did.
So what does the time have to do with what I'm asking? Did you have that conversation with the policeman?
Yes, I did.
Okay, what did you tell them?
I told him that he was the father of the person that I was testifying against. That's what I said.
Okay, and did you tell them anything else regarding his physical description?
All I said was I knew him and I seen him. That's all I said.
Okay, now, with respect to the handgun, I think you're pretty clear that you don't know who shot what, right?
I don't believe it was him. I believe it was the other person trying to get me out the way just for me to leave so I won't follow them to where they were going.
Your Honor, I have nothing further.
Can you read your letter?
No redirect.
I'll wait for you.
Is too young? He's young.
Ready for the city.
How you call him?
Yeah. She called me later, when you said we were leaving the week.
She was one, it was the other.
What I just said.
No, not.
What they just testified did not want to leave.
Oh, she already issued.
Yes.
Thanks for mother's day, or dad's day. Yeah.
We're gonna go through that shortly.
That's-
I don't see that his name is anywhere in the report.
Here's the court, what the person may see. Raise your right hand. Raise your right hand.
Yes. Just make sure you keep it once you get situated. Have that right.
Good afternoon, Ms. Young. Could you state your name for the record, please? Ms. Young, I wanted to take you back to the day of May 26, 2024. Do you remember that day?
Yes,
Okay. And were you at the location of 5027 Braden Street?
yes,
And is that location in the city of Detroit?
Yes.
Wayne? Okay. And what happened on that, at that location that we're doing for today?
my daughter was almost killed.
Okay. And who is your daughter?
Ariel MC.
Okay. And when were you at the location that day?
Yes,
Okay. And when were you first made aware that something was going wrong?
she called my phone and was blowing in front of my house at the same time.
And when you say blowing, do you mean blowing?
Her horn, I'm sorry.
Okay. All right, and And what happened after your daughter was calling you and blowing horn outside the house?
She explained to me on the phone what she had went through, and I put pajamas on, came outside, and she walked me through everything that happened.
Okay, and did you ever go outside?
Yes, yes, ma'am. I came outside to her where she was.
Okay, and you observed your daughter outside, is that what you said?
Yes,
Okay, did you observe anyone else outside?
no, I didn't.
Okay, did you see anything around that area?
I didn't see anyone.
Did you see anything at
Yes.
all? Okay, and what did you see?
I gathered items, a glass bottle, a water bottle, and a t-shirt, all with the shirt smelled of gas, the two bottles still had gas in them,
Okay, where did you find those?
like about 10 feet away from her car.
Okay, and was this, how do you know it was gas?
I could smell it, it was strong, I could smell it was gas.
Okay, did you call the police in regard to this incident?
Yes,
Okay, did they make a scene?
yes,
Okay, and, did the, police recover these items?
no,
Okay, so, did you recover them?
yes,
Okay, did you notify the police of
Yes.
okay,
Notify the police of what?
of the, glass bottle filled with gas, the plastic bottle, and the t-shirt?
yes, ma'am.
Okay. And, did you observe anything else outside of your home?
When it hit daylight, I discovered a bullet case. I found that bullet cases in the parking lot that's next to my home.
Okay, and how far away is that parking lot from your home?
Probably about 20 feet.
Okay. And, what if anything happened after the police arrived?
And
What happened when the police arrived?
the police arrived and they took a statement. They didn't look around, check the area or anything. They just took a statement and left.
Okay. No further questions for this witness.
No question, Your
Next year, release, they want to leave the courthouse.
I'm sorry?
They're good to leave the courthouse.
Go back.
Okay, wait. Any other witnesses for the people?
No, Judge.
Any defense witnesses?
No, Your Honor.
You can begin arguing.
Judge, in regard to, count one, well, first I'll say that the people are moving to bind over as to both counts in this case. With regard to count one, witness intimidating, committing a crime, threatening to kill, the people are relying on jury instruction 37.4B, which states that the first element is that, that the complainant was an individual who was testifying, going to testify, or going to provide information at an ongoing or future official proceeding. And then it goes on to describe an official proceeding. We did hear testimony today about, from Ms. Mincy stating that she is involved in another case in, regarding Latasha Pace. And that case is in regard to a home invasion, extortion, felonious assault, arson, prep to burn, among other charges. She did say that the case is ongoing and she was in this exact courtroom testifying about that case in the time of May. The second element is that the defendant threatened or tried to intimidate the complainant. Judge, in this case, we heard testimony from Ms. Mincy, who stated that she was in her car, she was sleeping, and the defendant, who she recognized as Miss Latasha Pace, her father, who is the defendant in a different case, was pouring gas on her car. And she also acknowledged that she observed another individual joining him in that act. She fled the scene and she was able to recognize and make a clear identification of who this person is. She's seen this person before, and she believes that this person was fulfilling the requests of other people and an attempt to avoid her continuing on with the case against his daughter, Ms. Pace. The third element is that when the defendant threatened or tried to intimidate the complainant, he or she intended to discourage the complainant from attending the proceeding, testifying at the proceeding, or giving information at the proceeding, influencing the complainant's testimony at the proceeding, either encouraging the complainant to avoid legal process, to withhold testimony, or to testify falsely.
Which one is applies for this case? Just read the part from that. You just read a whole bunch of options. Which one do you think applies for this?
And also just for the record, Judge, she indicated that the other matter also concerned an arson count, which it does not.
Correct. For the record. So out of all of the options you just read in the third element, which ones do you believe are you arguing that apply for this case?
Judge, and I will clarify that.
Okay.
Thank you. I believe there are several that could apply here. I think that the scheme in which the defendant was acting in this on this day applies for preventing the witness in general from attending her current court proceeding that's taking place against his daughter. I think that the defendant is attempting to have her not show up, have her not further testify in this case.
Is that in the jury instructions? So you just read, I just wanted to be clear. You just read that he intended to discourage the complainant from attending the proceeding. Does that apply in this case?
Yes.
Did he intend to discourage the complainant from testifying?
Yes.
Did he intend to discourage or discourage her from giving information at the proceeding?
Yes.
Intend to influence the complainant's testimony?
We believe so, yes.
How?
Influencing her testimony would be to withhold the testimony, to have her not testify.
Okay, next. Intent to encourage the complainant to avoid legal process.
Yes, committing a criminal act, essentially harming or killing the witness would encourage her not to, or would encourage her to avoid continuing the legal process.
You don't have to have all of it.
Okay.
You just need, I just want to know what your clear argument.
Yeah, the people are recognizing that a lot of these categories fit, but we do, for efficiency purposes, the ones that you've mentioned do apply in this case that people are arguing.
Withhold testimony?
I'm sorry?
What about withholding testimony?
Yes, the people are also including that in there, or to testify falsely.
And interrupt, but it just seemed like they all didn't fit. I wanted to know which ones you believe were applicable in this case.
Okay.
All right, so I stop you there. The rest of the instruction says it does not matter whether the official proceeding took place, as long as the defendant knew or had reason to know that the complainant could be a witness who was going to provide information at the ongoing proceeding. Okay. To the fourth element.
The fourth element reads that the defendant's actions involved committing or attempting to commit a crime. In this case, the element states that committing or attempting to commit a crime, in this case, the defendant did commit a crime, prepping to burn a vehicle. And he also threatened to kill the person by pouring gasoline on a running vehicle.
Judge, Your Honor. A threat to kill someone needs to be more than just pouring gasoline.
So,
Counsel's mischaracterizing a couple things. I can wait.
no, there's no need to wait. So we can go back to the second element. It says second that the defendant threatened and or tried to intimidate. Which option are you arguing?
The second element,
The second element.
tried to intimidate.
Okay, so threat is not part of this argument because it states in the jury instruction that a threat is a written or spoken statement. So we will disregard the threat language.
Okay, and in regard to the prep to burn, personal property, the first element is that the defendant put some kind of flammable, material, or device near the property and, or aided or persuaded someone to do so. In this case, the defendant did place gasoline directly on the property, which is a vehicle, Chevy Malibu silver that is owned by the witness. The second element is that when the defendant did that, they intended to burn, damage, or destroy the fire or explosive of the car, and in this case, the defendant did in fact intend to burn the vehicle by pouring gasoline. There would be no other intent that would be inferred there. In regard to the third element, that the property had a fair market value, when the defendant intended to burn or did burn it, and this one we're using C, which is the property had a value of 1,000 to 20,000. And we did hear testimony from Ms. Mincy stating that she did have the vehicle appraised and appraised between $5,000 and $7,000.
Appraised by the Detroit Police Department.
That's correct.
Officer.
Yes. If the with that, the people move to final verdict.
All right, that's a lot to unpack. So let me just begin with the first count, which is witness intimidation. The fact that the allegation that this is somehow connected to the other pending case has not been established, other than Ms. Mincy saying that he's the father of a person that committed a crime against her in another case. I think that to intimidate a witness, you would first need to have that as an intention, and it needs to be more than just a relationship. Even if you take her word that my client did that, it doesn't necessarily indicate his intent to intimidate her as a witness in an official proceeding. That just alone doesn't do that. His relationship to the other person in the other case is not enough. There needs to be more to establish an intent to intimidate the witness. And there was a plethora of different indications in the court rule, I think. Discourage, threaten, intimidate, all those things have to be established by more than just a relationship between my client and another person, party to another case where this person is. To be frank, Your Honor, that would have been where the audio and video that we were arguing about last time would have tied it up. Since counsel did not present evidence of anything of the sort, I would argue that count one has not been established because it required more than just speculation that because he's related to a party to another case, it was his intention to intimidate. And that's, of course, assuming that the identification is even accurate. With respect to the value in count two of the 2013 Chevy Malibu, I find it improper that we take an appraisal of this vehicle from a Detroit police officer. Even if she had said Blue Book or Carfax, anything other than just a police officer saying that this is the value of the car and then her not having anything in writing. And the car was not ignited, it's not, I don't know if that's the proper word, but the car was not lit up, so really a car wash, a $15 car wash could have solved the problem. The car was not alight. So because we don't have an accurate statement of value on that car, I find it, of course, at the bottom, it might be worth $1,000, but between 1,000 and 20,000, I highly disagree with that. It's a 2013 Chevy Malibu. So with respect to count one, Your Honor, I would ask the court to take a beat and seriously look at whether or not the tie necessary has been made by the testimony of this witness. Thank you.
I'm sorry,
Yes.
you were wrong.
Briefly, with regard to the mere incidental relationship of the defendant in this case and this particular case, the defendant in a prior case, the witness involved in, the people would argue that there's more than just the mere relationship, and that intimidation in fact has been established. We did hear today from Ms. Mincy stating that the defendant, Mr. Early, was present during the home invasion. And he was also involved.
I'm objecting again, Your Honor, that's a mischaracterization of the testimony. Ms. Mincy did not say he was present during the home invasion.
Did not.
She said that where she was taken to, he was present. Not that he participated in the kidnapping or was present during the kidnapping. He was present where she was taken.
Okay.
That
She
was
did
her
say that he was
testimony.
present. She never said that he was part of it. But I think the kidnapping was ongoing between two locations.
But that's my point, but I didn't want it to be misrepresented that he was a part of the initial alleged taking of this individual.
No, because I actually remember that testimony, he was not involved in that.
He was not one of the defendants in that case, but he was in fact present during the kidnapping. So the people would just argue that there is more than just a mere relationship that would tie the intimidation, in this case, to the witness. The second point is that, the people did ask the witness, whether it was appraised, and she did allude to the fact that it was appraised, by an officer. And, the appraisal came back on Blue Book for,
And testimony.
okay, came back for $5,000 to $7,000
Came back where?
from the appraisal by the officer.
So for first element, I am going to find over. Your instruction gives the option on the second element for intimidation and or threat. I don't think this is an issue or a case of threatening. The jury instructions are clear that a threat is written or spoken. However, I do believe that in pouring gas in someone's car while they're sleeping silently is a form of intimidation. As far as the third element, I believe that people have satisfied probable cause standard if he tried to intimidate the complainant by intending to discourage her from attending the proceeding and or testifying at that proceeding pending on the kidnapping. And she did testify, first witness, that Ms. Mincy, that the defendant was present at some point she was being kidnapped. So it is safe to say that the defendant had reason to know, or has reason to know, that she was involved in testifying on that case. And then four of the defendant's actions involve committing or attempting to commit a crime. That attempt would be the arson, preparation for a crime. For count two, Ms. Vella, there's a problem here. The value, and I didn't get much of an argument as far as, or rehabilitating the fact that the officer told the complainant the value of her car. Hearsay exception works for if the owner is stating what the value of the vehicle is to someone else who's testifying. That's not the case here. She's stating that the officer, she doesn't know who, I'm just telling, just reciting what was based on the record, not what's in the file, what everyone else may know. But then that officer told her the value of her vehicle, with no validity to it. I don't know how she got to that number, who this officer is, if this person specializes in the value of vehicles. So for count two, I'm not going to buy over because it requires for the, let me get the element correct here. For one of the elements to establish at least $1,000 or more, but less than 200. So I'm gonna buy you over, sir, on count one, I'm gonna dismiss count two without prejudice for insufficient evidence.
Right, I would ask for this indulgence and a motion for bond reduction. Okay, so, my client does have a rough past, so I'm not gonna pretend that he's not had any encounters with criminal justice. I would simply ask the court, give some consideration to a tether. My client has, suffering with pain in his leg, he has pins in his lower leg. So right leg, right? He has pins in his lower right leg, pins in his upper femur, the same leg. He only has one lung. And so his exposure to health issues while in custody are extreme. I would ask the court give some consideration to having a tether to his home. As the court is aware, my client is preparing to defend against this case, has no reason to abscond, is not a threat to the community. The behavior alleged is threatening, to the extent that Ms. Mincy has alleged that she was in fear. I have to acknowledge that. However, I would ask the court consider his health issues, and the fact that he wants to proceed to defend himself, he's not a flight risk or is a threat to the community. If in fact counsel is to be believed, individual, one individual, not the community, under threat from this person has already testified. It's not a threat to the community at large. And a tether would kind of maintain distance, a safe distance, and remove any threats she might receive. Thank you.
So, Judge, the people would object to the reduction in bond. The witnesses in this case, Ms. Young and Ms. Mincy have expressed their deep concern about their safety. In this case, they reached out to us multiple times. They stated that not only is the defendant, Mr. Early, appeared to be after them with regard to the first case, but other family members are discovered to be involved in this. They repeatedly expressed their concern for their safety. They don't want any of their identification factors out there. They don't want anything out there with regard to any of their personal information. We don't believe that the defendant is just a harm or a threat to this witness. We believe that he's a threat to society, to community, because of the case involving his daughter. So the people would move to not have the bond reduced.
Okay. I can order this. So when we found over here, we have that, Ms. Mincy has been through a lot, and I don't want any more incidents, and I think the best way to make sure that she doesn't get threatened again, or kidnapped, or harmed, or killed is by being used in custody, right? So, there's no contact order. I don't think that there's any issues, correct?
Right, not that people are arrested.
So just continue to no contact with anybody, Ms. Mincy or her family. Third party, no instructions, via phone, however, letters. And your arraignment information date will be 1 week from today. That'll be July 17th at 9:00 a.m.
Can you mark his file back?
I can. And then I have a dismissal for the second count.
Step this way, Mr. Earl.
You're right. March 17th.